And I like to get their acts and statutes and beat them over the head with them till they submit. And they always submit. But I always give them a way out. And then I'll hammer them for damages and they'll settle out of court every time.
In this episode, I'm going to be interviewing the paralegal who's been helping Sudbury, Lavenham and Hadley push back against their district council, who have imposed parking fees upon their small market towns. Now, I'll warn you ahead of time, this is a long video and it's not going to be for most people because we're going to do a real deep dive into the legislation as well as all of the rules that bind the councils, and there's a lot more than just the Nolan principles that they have to contend with. Now, nothing that we say in this video is to be construed as legal advice. It is not. We're merely going through the process of the letter before action that the paralegal has written to inform the council and give them an opportunity to reconsider their position on these parking fees. The other reason this video is quite long is because we actually got a reply to the letter that the paralegal wrote. So at the end of the video, we will cover that and his next action steps, which were very, very interesting. So those of you that are wanting a 15-minute entertaining summary, this isn't going to be it. We really are going to do a deep dive into the legislation, which, let's face it, with the best will in the world, is rather tedious. But it's very important that we know how to do all this. It is our highest hope that throughout this series we will all learn how to do this for ourselves, because having others fight our battles is not what this is about. It's about self-empowerment and us taking charge and doing this. Just imagine a society that's full of people that know their rights and know how to act upon them and can legally challenge any authority or business that oversteps the mark. But even if you don't make it through this episode, do make sure you watch the follow-up that Damian and I filmed just the other day on our rights. Because once you know what your rights are, you will know when others are violating them, and you will also know how to defend them. And that is very important, especially in this day and age, where our individual rights and freedoms are being eroded more and more every second. So yes, learning law is about as exciting as lifting weights, but don't focus on the tediousness of that. Focus on the end result, getting strong and capable and able to stand up for ourselves. And that is worth all the tedium that is involved. Now, many of you will want Damian's contact details, but I'm afraid that's a no-go. He is absolutely snowed under and he cannot take on any more, which is why he is teaching us to do what he does, so that we can do it for ourselves and spare him fighting everyone's battles, because he simply can't. But at the end of this video, I will give you some links that you can see more of his work. Right, okay, I am here with the very fabulous Mr. Damian Jones, who has been wonderful help to the people of Sudbury. He is a paralegal who has been advising them on how to tackle what Bayberg District Council are trying to do with enforcing car parking charges on Sudbury, Lavenham and Hadley when they have always been free. Now, if you're not familiar with these towns, certainly Sudbury and Lavenham are drive-through towns, so you need a good reason to stop there. So this could be absolutely the nail in the coffin for these towns, and everywhere is struggling. But this will really kill their trade. So Damian has donated his time, energy and information to help them push back against what the council is doing. So thank you so much for coming on, Damian. Much appreciated.
Absolute pleasure to be on. And I'll just say, with regards to the councils, my quote would be, you get what you are prepared to suffer. So we all have an inherent responsibility to hold our public servants accountable. And there's a legal framework that we haven't been taught and haven't been educated in the school system with which to do this. Because as a collective, as a people, and we also have very, very powerful individual rights. And there are many codes and much legislation that binds the actions of the civil service, our public servants, that are fast thinking that they are the master, but they are there to serve us. Their powers of the local authority are delegated, limited, and there are many acts that bind them that limit their governing power. Right, with regards to this particular council, and I will just address this to all councils, I'm just a small cog in a very, very huge national and international legal framework. There are many of us, 15,000 plus, domestically and internationally. That's paralegals, that's lawyers, that's solicitors, that's attorneys. And we have come together organically because this is happening everywhere. There has been framework from central government, from non-government organizations, pushed through central government to local government, who have had its funding clipped so that they go ahead with these programs, with these policies that no one has asked for and nobody wants. But fortunately, there is a framework where we can hold our local councils to account should they not fulfill their statutory duties and obligations. So in this case, it appears that all democratic legal avenues were sought and exhausted. So we've had to send them a pre-action protocol, a letter before action. And in a letter before action, it's a legal letter just outlining what they should be doing, what their duties, their obligations are under statutory law, what their obligations and responsibilities are to us as their people. They are our representatives. And just outlining, first and foremost, and this is what I'm going to go through first, exactly what they are subservient to in the way of legislation and their own codes of conduct.
Before we get going with your doing a breakdown, one thing I think we probably should say is that you don't want your work used as like a template, cookie cutter style, because that is not what this is about. If people are sending out letters that they do not understand, and also everything you do is case specific. So please don't think that you can just roll this out to every council. You can't. And that's what I hope we'll cover in future episodes with Damian, that he'll actually give us a little bit of schooling on how we can write these letters for ourselves. So basically we all need to learn to fish and not have someone do it for us. But anyway, sorry, over to you, Damian, to walk through.
I'm so glad you've said that, because this is specific to their plans for increased parking charges. So I've used the relevant legislation to counter that, and just to bring to their attention their legally binding duties and obligations. So we start with the fact that the councillors are a group of men and women given delegated authority, limited to the will of the people within its geographical location. The district served and bound by the legislation governing their statutory duties. Okay, so let's have a look at their agreed codes of conduct. So what are they bound by with regards to codes of conduct? You have the Local Government Association Model Councillor Code of Conduct 2020. And there are 10 principles that they have to, or 10 codes of conduct they have to adhere to within that.
Is that the Nolan principles, or is that different?
Well, no, that's slightly different. That's the Nolan principles of public office, which they're also bound by.
Mm-hmm.
So within their own codes of conduct, for example, this particular council, their council members' code of conduct is within their constitution, which is on public record. It's on their website. And again, you can Google that. That mirrors the governing code of conduct, which is the Local Government Association Model Councillor Code of Conduct. So you've got the two. You've got the LGA, Model Councillor Code of Conduct, they've got to adhere to. Then their own constitution has written in their own council members' code of conduct. Okay, so that's two. They also have the Nolan principles of public office. Now,
is there going to be much difference with each council's constitution? Does it vary much?
No, they're all modelled on the Local Government Association Councillor Code of Conduct.
Okay.
they pretty much copy and paste that.
So basically, once you've looked through one of these, you've got a pretty good idea, but it's always good to double check your local council's constitution just to make sure.
Yeah, it will have their members' code of the council members' code of conduct within that. So it's worth reading that. And in this, certainly within the LGA, which is the preceding governing body of in regards to code of conduct, I've found what I would consider to be several breaches. So, for example, in Section 5 of the General Conduct section of the LGA, Model Council of Code of Conduct 2000, it states, disrepute. As a councillor, I do not bring my role or local authority into disrepute. Now, as a councillor, you are trusted. Think about that. Trusted, entrusted. So that would denote a breach of trust if you were to go against the Nolan principles and their codes of conduct. So it states here, you are trusted to make decisions on behalf of your community. You've got to hold their feet to the fire. You've got to hold them to the words that are written here. These are provisions, okay? These are rules, codes that they have to adhere to. So what are we saying here? As a councillor, you are trusted to make decisions on behalf of your community. So in this particular case, there was a petition of at least 8,500 signatures. Now, this is a fairly small area. 8,500 signatures is a lot of people.
It is. I've actually found out since then it was 10,500 people, but they only accepted the 8,758 that lived in Baber District Council area.
Well, that's semantics on their part. At the end of the day,
that's a lot of people to ignore.
Because I've got other angles which I'll come into with other legislation that they're also bound by. But the point is this, right? They have a statutory duty to the people they represent. Okay. Now, they can't breach that duty, right? Because a breach of duty is a negligent tort. Okay. That's a problem. And they're all personally liable.
Can you explain what a tort is for people?
Well, a tort is a wrongdoing. So you have a right and you have a wrong. That's it. So a wrongdoing is a tort, and it's pretty much a common law cause of action. It's how you can go after them for a civil rights violation in tort. Or you have the tort of misfeasance. Misfeasance is an unintentional wrongdoing. Malfeasance, which if they continue along this action, where we have to go and do a judicial review, I'll come into that in a minute, because they've got a 14-day opportunity to reconvene the cabinet and revoke their original decision over the vote. Again, we'll get into that in a second. But malfeasance is an action against the holder of public office, alleging that he has misused or abused their power. Now, that would come about if they're going against the will of the very people, the community they represent. It can't be any simpler than that.
Yes.
So,
and I noticed at the top of the letter, you had put all the councillors' names that have voted for this. So they know it's them. They are the ones that are liable. So you're not going after Baber District Council. You are going after the specific councillors who had voted this through.
Well, look, people have got to think about this, right? What is a council? A council is a fiction in law it's a two-dimensional paper construct, okay? Or it's a building. No, it takes people there, men and women, to make it function. So it's those people that make those decisions that are liable. Stop being drawn away with a two-dimensional paper legal fiction logged or registered at Companies House or the building. I'm not going to bring the building into a court of law. I'm going to bring the men and women that have abused their position or ignored the request, the will of the people they serve. So what I brought to their attention is their codes of conduct too, and the Nolan principles. And I've also put in the facts. Now, you've got to state the facts very simply to them, which is that the council received 8,500 signatures. That was the information I had at the time. The fact it's more is wonderful. In the form of a petition from the people within the district. They serve a district. That's the legal framework. That's the legal construct, their district. The district of, okay? Specifically the market towns of Sudbury, Hadley and Lammingham at this juncture, to not change the current free parking arrangements, okay?
Mm-hmm.
Now, I'm going to ask this question back at you. If they change that, if they start, well, first of all, as it stands, have those three market towns, have their economies prospered? Have the shops prospered through having free parking? I'm going to put that back to you.
Yes, although I don't know if they've ever not had free parking, but I know the locals there, all the local businesses were saying, and so many people in the comments said, I'm not coming to Sudbury if you charge me for parking. It's one of its, selling points that you can go in and you've got 3 free hours.
Right. I'm gonna show you another angle, and hopefully you councillors there are listening to this, because this is more legislation that I haven't needed to put in here, but I'll bring this up. It's got here, specifically in section 57 of the Road Traffic Regulation Act 1984, that if they consider it necessary to relieve or prevent traffic congestion, or, which is a disjunction, or preserve local amenities. Now, I'm going to ask you, what is your understanding of the word preservation, to preserve, Rachel?
To keep something as it is.
Bingo. So we simplify this. Okay, this isn't complex stuff. People are just frightened of legislation. They needn't be. Right, what would you consider to be a local amenity?
Well, certainly free parking, shops, businesses.
You've got it. So they have the power to provide parking spaces under section 57 of the Road Traffic Regulation Act 1984. Okay?
Mm-hmm.
If they consider it necessary to relieve or prevent traffic congestion, or, so it's this or it's this, disjunction, okay? It's commanding one or the other, or preserve local amenities. So that's a provision. Now that power has been conferred to them to do this. So it is a statutory provision. Now they would come back, they would argue that they don't have a statutory duty to provide parking.
Yes,
but
they already have come back and said that.
Well, we've got that from a Freedom of Information request.
Yes.
And that is correct, because I could successfully argue that under this section of this Act, that they have a duty to preserve local amenities. So then the plot thickens. I'll bring your attention to, bearing in mind, it can be successfully argued that because they have the power conferred to them, the local authority, they have a legal obligation to preserve the local shops, i.e. amenities, not destroy them, yes?
Yes.
So, parking charges. If it ain't broke, why fix it? There's an old adage. So let's take this a step further. In the Act that I've already hammered them with in this particular letter that we'll come to, this is something aside. We'll take what I'm saying a step further. In the Localism Act 2011, which they are bound by, one of many acts to limit the power of local governance. Remember that. So don't be fearful of the legislation. It's to limit the power of local governance. Remembering their authority is delegated, limited, and derived from where?
Well, the government, but ultimately us.
Thank you. From us. The government are just there in a fiduciary capacity. Okay? They'll convince you otherwise, but it's nonsense. So the Localism Act 2011, Section 3, which states limits on charging in exercise of general power. This is very important. So think parking charges. Subsection 2, the general power confers power. That's us conferring power, or government, the legislature conferring power, but that power is derived from us. Take it all back. Take it from point A to point B. The general power confers power to charge the person for providing the service to the person only if, subsection A, the service is not one that a statutory provision requires the authority to provide to the person. Now think about that. So I'm gonna answer that for you. I aver that the local authority have to provide a service in the form of parking spaces, because we've already highlighted to preserve local amenities. As this is a statutory provision highlighted within Section 57 of the Road Traffic Regulation Act 1984 to preserve local amenities, then pursuant to Section 3, subsection 2A that I've just read, then they cannot charge for that service.
No, and also it's on public land, is it not? Paid for with public money. So don't we own that car park? Well, I don't live there in that district, but the people that live in that district, is that an argument as well? I know you're going for the strongest, simplest one, but this is just an add-on.
Well, no, this is something completely separate. I haven't even put this into the letter for action because I haven't needed to, because I've only had to concentrate on the fact that 8,500 signatures were ignored, that they were in breach of trust, breach of their code of conduct, and breach of their statutory duties by doing so.
Yeah, so there's no need to overcomplicate these letters with every last thing thrown in. You just go for the easiest one.
You know, I'm just showing you that there are so many ways to skin the cat.
Yeah.
We've got so much ammunition and so much power as a people, as a collective, and as an individual, our individual rights, which you and I were discussing the other day, you know, codified in the superior statute, the constitutional statute, the Bill of Rights, which declares in there, it's enacted, that it's the law of the land forever. And Parliament cannot repeal it. I had a council trying to tell me it had been repealed by the Statute Law Revision Act 1948. And I said to the individual, you read the letter, didn't you? So you laughed at me. I said, you haven't read it, have you? Because at the bottom of the Bill of Rights, on the statute books, it says there are two textual amendments. Now, a textual amendment is not repealing it impliedly or expressly. Yeah, they cannot repeal it. It's the law of the land. And
it goes hand in hand with the coronation oath. So it's been used recently.
You've got it. Instead of having an opinion, you back it with facts, with evidence. So everything I do now, I don't have an opinion. An opinion is hearsay. It's irrelevant. I back it with facts, as you do, you know, with your, you know, dispelling the the green bubble.
Zero. Yes.
So this is what we're up against. It's called lack of data analysis, lack of research, and cognitive dissonance. And it's emotive thinking without thought, without rational. And the beauty of the law is it's unambiguous. As it is written, so it shall be. So yeah, I'll come back to this. Basically, what we've used is the fact that we can prove beyond reasonable doubt to a High Court judge for a judicial review that they have breached public trust, they've breached their statutory and fiduciary duties, and they've breached their conduct codes. The basic premise of this, they're trying to plead poverty, but at the end of the day, they can get more funding from central government. Now think, taxation. We're one of the most heavily taxed people. Whether you believe tax is right or wrong, and there's many arguments. I've read the tax laws back to front, so I can dispel the myth of council tax and the fact that you can't tax a right to own property. And as long as you're not engaged in commerce, i.e. duties imposed and excise within that property, then they can't tax it. You can't tax a right. And you have a right written into 3 constitutional statutes to have spiritual, religious beliefs, to have properties, okay? and have civil rights. They've been codified. So you can't tax those rights, yet they are. It's really central government are the hub of income taxation, which again, there are fantastic arguments about taxing your labour. You can tax commerce, you can't tax your labour. But then again, that's for another matter. The point is this, the local government, i.e. the councils, can put in for grants and more funding from central government rather than imposing more taxation in the form of parking charges on the local community. So parking charges, taking into account people are currently struggling financially with a well-advertised cost of living crisis. 2, local businesses were hit hard financially with a well-advertised COVID pandemic starting March 2020. Those businesses are also up against the internet giants, Amazon et al. Yes? So why are we hitting them further when the council should be requesting further funding? And they can. I've read their policy framework and how they can get funding from central government. So I know what they know.
You see, their excuse is they've said that the government over the next 4 years is going to reduce the money they get by nearly 7 million. So they say we have to charge for car parking, otherwise you're going to have to decide which essential services get cut. So that's the blackmail that's gone in with this.
No. That's emotive thinking again. So they're giving you an emotive answer or an emotive rationale. Well, you're going to have this or you're going to lose that. It's emotive. No, that's not rational. When I've read their policy framework and they can put in for grants and extra funding, they can. So that's nonsense. Spurious. No, the fact is that we know, you know, and they know it's going to have a huge impact on those 3 market towns. Right? And free parking encourages people to come to those towns to spend a day, 3 hours where they can park up and go around the local shops. And while they're buying things and actually, being part of a community and speaking with people and spending their money locally, putting into the local economy, which is important because that's covered in the Act that they're bound by. So we come back to just think local economy. So free parking is encouraging and subsidizing the local economy. Remember those words, because we're going to come back to that. And while you're there shopping, you're also nipping in somewhere to the bakery, you're sitting and having a coffee, or you might go and have a pint or a glass of wine. It's good for all. This petition was noted, it was recognized into 20th of February within the public document pack, dated 08/04/2024, with particular attention to agenda item 8, which states as follows. A petition not to change the current free parking arrangements provided in council-operated parks in Sudbury, Hadley and Lavenham was debated by council 20th February 2024 and voted in favour of being noted. So they had to vote on it just being noted on public record. Now that tells you how this system needs streamlining and how these people propagate a system that is designed to subjugate us all anyway. It's ridiculous. Anyway, it is a fact that the local businesses rely upon the public to be encouraged to using their services in a time of great financial hardship and competition from the huge corporate online providers. Okay, so the council enjoy business rates from the local shops, from the local amenities, from their commercial endeavours. That social taxing contract works both ways, and those businesses have a right to consideration in the form of council encouraging those customers return. Free parking goes both ways. You can't take the money, business rates, and then not preserve the local amenities. That is a social taxing contract. So they have to give consideration in return. Yeah, it can't be one way.
It was always going this way. That's what has upset people. Although they've gone through
the process. It's been on the cards for a long time, and they've just been pushing for it since 22, I think, or possibly even before. The idea has been floated because they just see it as an untapped revenue stream rather than the big effect. They're looking for the short-term gains and completely ignoring the fact this could decimate the businesses.
It can and it will.
I mean, we've had so many comments from other areas that this has happened in. And, you know, over 100,000 people have viewed that video, and there hasn't been a single one saying, oh, no, parking charges are fine. It made no difference to our town whatsoever. Everyone was like, this killed our town, or they listed somewhere they used to go that they don't bother with anymore.
The proof is in the pudding. That's the will of the people. The people have spoken, and these people have got to stop pushing their own agendas and actually, you know, doing right by their communities. You've got the facts, okay? So the fact that the local businesses rely upon the public to be encouraged. You've got the fact that if the council have been financially mismanaged, then the community council serve and not to suffer the burden as a consequence. Councils simply need to ask for more funding from central government through grants as per their policy framework. And I've read them. Those are legally binding. It is important, pursuant to the Local Government Association Model Councillor Code of 2020, that the councillors can be held accountable, i.e. liable, okay, and all adopt the behaviours and responsibilities associated with the role. So it avers within there, as councillors, they represent local residents. I'll say it again. In the LGA, Model Councillor Code of Conduct 2020, right, which they are bound by, it states, as councillors, we represent local residents. And we work to develop better services and deliver local change. The public have high expectations of us. Entrust us to represent our local area, taking decisions fairly, openly, and transparently. They've breached the public trust, and they've breached that specific code, have they not?
Yeah,
if
absolutely.
they just ignored 8,500 signatures and the will of the local people, have they not breached their duty there?
Yeah. They always try and palm it off is that isn't a significant number of people, or that isn't truly representative, but that is a lot of people for a small area.
They can't get past it.
No,
they can't get past it.
Especially as we know the figure was really 10,500 people, but they've manipulated it to just under 9 because they can.
I would wager that if you went round to everybody, if you went door to door, 95% would say no to the parking charge. They damn well know it. When and if we have to put the paperwork in front of a judge, because they've got a chance of redemption here.
Yes, that's one thing we haven't really covered, is it? The point of this letter is to give them the opportunity to remedy it without going to court. So this is your first chance, but after that, it's court. Is that correct? Would that be the next step if they?
We would escalate it to the LGA, the Local Government Association Ombudsman, which I can never pronounce, but you know what I'm saying.
Well, my experience with the Ombudsman is they are of little use.
No, but this is part of the pre-action.
This is the process, yeah.
Of course, I go from point A to point B. So yeah. Point B is the judicial review, which we'll get because no judge. You know, you apply the reasonable man test to everything you do in law, and we're going to be putting this paperwork in front of the adult in the room, the reasonable man being the judge, and we'll have followed all of the pre-action protocol. And if these people are still acting in self-interest, willful negligence, malfeasance, we're going to iron them out with a judicial review. It's going to attract a lot of unwanted publicity for these people, and eventually we'll sue them for damages anyway. So,
and it will be costly. You know, the thing is, so many people, certainly in the comments and that I know, have so little faith in our judicial system because we've seen so much in the last few years that everyone says it's an old boys it's a network of the old boys club and they will do what they want to do. Is there, with this, in your mind, is this so cut and dried they can't do anything with it?
The the law system functions correctly as long as you follow the procedures, the process, and you articulate your arguments in the correct way. You support it with evidence. You have to put an open and shut case, something in front of the judge that cannot be contested. So I've no doubt that these people, they've got 14 days to reconvene their little meeting, the cabinet, and get together and do the right thing. And they've got the power to revoke their original order. They can do that.
I don't think they will, judging by what I've seen. They are so determined to go with this. And there just seems to be a lot of personal ego in this decision that I'll be amazed, even though I can see what you've done. I can understand what you're talking about in the letter. Just seeing the way they've behaved through the entire thing makes me think, I bet this is going to have to go further.
You've got to be prepared to be in for the long haul. At the end of the day, there's a legal maxim that states, he who leaves the battlefield first loses. So at the end of the day, I always do the long game. I've just countered an unlawful fine by playing the long game and just giving them the rope to hang themselves. I've just catalogued all the crimes, all the acts criminal in nature, the lack of the administrative legal simulation, and the circumnavigation of due process, and just catalogued everything they did for my case file and legal memorandum from point A to point B. Now, we're at point B now, where I brought it to its natural conclusion, i.e. justice, where they had nowhere to go, but I gave them an out. So they've now rescinded that. The council put it back to the school, and the school said, well, we don't want anything to do with this either. And now I should sue two parties for damages, because at the end of the day, you've got to be prepared for the long haul. But what I'm saying is this: they tried everything: coercion, menaces, threats, and I didn't lose a wink of sleep. I was just, okay, thank you. This letter, it's another exhibit. It's a malicious
So basically, from the outset, you've got to be willing to see this through to the end. You don't just throw a few notices at people and go, okay, I hope that works.
No. It's the long haul that you are dealing with an old paradigm. These people, look, they've got a title of office, they've got huge salaries and pensions, and they believe that they have a place in social hierarchy. It's a point of ego. Yeah. That's what you're up against. And I had this, obviously, over a 2-month period. Now, who backed down? Who brought this to its natural conclusion? I did. I didn't back down. They did. They had to.
And also, they're not used to being challenged in this way. So the more of us that can do this, the quicker it's going to turn around that they get, actually, we're their servants. It's not the other way around. There seems to be this God complex that takes over with some, not all, councillors. And they seem to think, well, they voted for me, therefore everything I think and do is correct, rather than actually finding out, is this what the people want? And the fact here, as you say, very clear case that 8,758 people said no. It's very clear. And there's that arrogance that's pushing it through regardless. So, yes, it's going to be an interesting one. I look forward to seeing it through to its final conclusion.
Well, Rachel, I didn't write this letter just for them. I wrote this for a judge.
Yes.
I wrote this, I had, look, we're following a pre-action protocol. So, quite frankly, I don't care if they ignore the letter or not. It's up to them, it's in their best interests to do the right thing and revoke that order within 14 days and actually start serving their community. It's in their best interests and in the interest of the public. But if they choose not to, then we'll escalate to the LGA. And then from there, we'll kick it up for a judicial review. And everything I've written, I had one eye on putting in front of a judge, and I know what the judge wants to see.
Right,
what
that's important.
Alleged evidence and articulated. This is obviously important for your viewers. So the code has been designed to protect the democratic role, encourage good conduct, and safeguard the public's trust in local government. Now, we've already proved a breach of trust, breach of contract, the social taxing contract, and a breach of duty. Okay? So I put here, right, they must act with integrity and honesty, lawfully treat all persons fairly and with respect, lead by example, and act in a way which secures public confidence in the role of a councillor. I've put these terms have clearly been breached when the vote went against the will of the local populace, i.e. residents, men, women, evidenced by 8,500 signatories, in the form of a noted yet ignored petition. Okay? Paying particular attention to the undertaking of a councillor's role in impartially exercising responsibilities in the interest of the local community. Right. So we've looked at disrepute. Now, there are 10 sections of the general conduct terms and conditions which have been breached, paying particular attention to section 8, complying with the code of conduct. They haven't complied with their code of conduct, and we can prove that. Yes? That's another breach of duty. So we can prove they breached their duties, breached the public trust. Now, this coincides with the 7 principles of public life, known as the Nolan principles. These are selflessness, integrity, objectivity, accountability, openness, honesty, and leadership. Now, the ones that I believe that they breached here are selflessness defined, which are holders of public office should act solely in terms of public interest. Well, do you think by ignoring the vote and the will of the people they've done that? Have they acted solely in the terms of public interest?
No, they haven't.
Rachel, it's cut and dry. They clearly haven't. You know, you've got to understand they're bound by these terms and conditions. Okay? They're bound by the terms and conditions of the 7 principles of public life. So that's the first one that I've pointed out to them. Objectivity defined. Holders of public office must act and take decisions impartially, fairly, and on merit, using the best evidence. Right. So I put in brackets petition, 8,500 signatures. Have they used the best evidence available to them? It's black and white. There's no ambiguity here. Accountability. Holders of public office are accountable, and I put in brackets, and liable to the public for their decisions and actions, and must submit themselves to the scrutiny necessary to ensure this. Okay, so I've just reminded them of that. So I am presenting here, and it is my belief that the named respondents have breached their duties, public trust, which is a breach of trust there, code of conduct, and a breach of their social contracts. And I've reminded them that all the information expressed within this document, this section is supported by their own Constitution, Part 4 Codes and Protocols, the Members' Code of Conduct, and pursuant to Section 27 to 34 of the Localism Act 2011. So now we're going to really hit them with the legislation. So we've explained that the council enjoy a huge revenue stream for the local businesses it serves, okay? And has blatantly ignored their requirements with regards to parking charges, which constitutes a breach of duty. Their actions to implement parking charges would ultimately cause a serious downturn in custom and therefore cause significant economic loss to the businesses, business owners and their dependents, i.e. the families. This can be proven should the parking charges be implemented October this year, when we can audit the accounts of the local businesses over 2 financial quarters, 3 to then 6 months, 2 quarters, which will provide the evidence of the shortfalls to be put before a judge in a separate class action lawsuit against the council if necessary. So that's another avenue. We can sue them for the tort of pure economic loss in negligence, okay? Which is also a branch of legal duty of care caused by loss, failure to the party to which the duty is owed. That is so easily proven in this case and would be with the audited accounts. So that's a separate thing, okay? That's, you've got the judicial review and you've got that. This is the legislation we've used because we're just pinpointing the nice simple point that they've ignored, okay, and that they've breached their codes of conduct, they've breached the duty. They've also a clear duty to adhere to the legislation that binds them. And in this case, pursuant to the Local Government Act 1999, Section 3, the general duty, which states subsection 1, a best value authority must make arrangements to secure continuous improvement in the way in which its functions are exercised. Okay, so they're the best value authority. They've got to make arrangements to secure continuous improvement in the way its functions are exercised, having regard to a combination of economy. So if they implement these parking charges, is that making arrangements to secure continuous improvement to the economy?
No, it's had the opposite effect.
They breached that section of the Local Government Act 1999, Section 3. So it says here, so having regard to a combination of economy, efficiency, and effectiveness. Right, well, economy. So we've just seen there's a breach there, isn't there? Subsection 2, for the purpose of deciding how to fulfill the duty arising under subsection 1, an authority must consult. So again, now we come into the two parties they need to consult. So this act is saying how important both the businesses and the local people are, and I'll explain, because in subsection A it says representatives of persons liable to pay any tax, precept or levy to or in respect of the authority, and subsection B, representatives of persons liable to pay non-domestic rates in respect of any area within which the authority carries out functions. So subsection A is the people, subsection B are businesses. So it states it has a duty to businesses and the people and to secure continuous improvement of the economy. I rest my case, Your Honour.
Yes, indeed. Brilliant.
So we then define the terms. A best value authority is defined in section 1. So we don't have any ambiguity here. Always define the terms.
So evidence the claim.
That's it. A best value authority is defined in section 1 of the Local Government Act 1999 as an English local authority. So then we check what an English local authority is, which is defined in section 1, subsection 2A of the same act as a county council or a district council.
Yes.
Well, this particular district council is a best value council and has a statutory duty to the economy in its district area, securing its continuous improvement and not destroying the local economy with parking charges, which will keep customers away from local businesses. And having had consultation from both persons liable for tax, i.e. residents, and the persons liable to pay non-domestic rates, i.e. business rates, commercial shops, in those consultations, this best value council, i.e. Labour, DC, were told a resounding no to the parking charges and further evidenced with a petition of 8,500 signatures, which was noted but ignored. This council has breached its duty by doing so and has contravened the provisions expressed within section 3 of the Local Government Act 1999. I rest my bloody case. So this is all for a judge.
Yeah.
So what we've said, we've put at the end liability, responsibility. We have advised our clients within your district area, both resident businesses, that your actions on Monday the 8th April 2024 were in breach of your duties as laid out clearly within this letter. You will be given 14 days on receiving this letter to reconvene all parties, i.e. the named respondents, present at the previous meeting and revoke the decision on the parking charges. Otherwise, we'll have no choice but to take further action against this council and named respondents by lodging complaints with the local government ombudsman, which I struggle to say.
You got it
and
that
then
time.
Putting in got it that time. I had to break it down. And then putting in an application for a judicial review to the High Court, which will bring moral scrutiny and expense to this council, as well as unwanted publicity. And we'll have separate grounds if they go ahead with it for a class action lawsuit, as previously mentioned. So we will remain undeterred on this matter and we will see this out to its natural conclusion. Now, remember this, we're coming from a foundation of truth. And when you come from a foundation of truth, when you hold your position, you win.
Yeah.
I never take a backward step, and I always win. As proven just using Article 12 Bill of Rights with regards to my local district council, and I put them and the local school into a bit of a problem. And I will now be suing them for damages. They've had to back down. They had no choice. They were in breach.
Well,
Does
the
that clear
people in
up?
those
Hopefully.
areas, they need this. You can see how damaging it's going to be. And yeah, it's just a matter of getting that through to them. So presumably this letter would have been passed over to their legal advisor within the council. I mean, I was told by one councillor, he was a Suffolk councillor, he said a judicial review cost £250,000.
Well, it all depends how and where we go about it. So that's something that I'll sort out in due course. Okay.
No, he was saying it cost the council that amount.
I was going to say it won't cost us that amount.
No.
Anything near that. So,
and besides, we've got a
another
good track record for fundraising for these types of things. So I'm sure our viewers will help us out if we need to go down that route, and all the people of Sudbury, Lavenham and Hadley as well.
I don't think you'll have to go down that route, if the truth be known. But like I say, I mean, I like the fact that you've had that was an officer, did you say, has actually pointed out the expense to the council?
No, it was a councillor. He is a Suffolk councillor, but we were chatting on another matter regarding what they're doing at Middlewick, and he was sort of saying, yeah, that a judicial review would cost the council 250,000
and then some. That's a bare minimum. This is my point. So you know, I don't think they're going to take this any further. I mean, especially if we kick up a complaint, because the ombudsman can fine them. You know, if they're balking about the shortfall, I believe that's down to financial mismanagement, and I have already explained to them that we will do full financial audits. We've got accountants on our team. We will put in the freedom of information request. We'll get 5 years of accounts. And if there is one impropriety, we'll find it. And we always find them.
Yeah.
So how far do they want to take this? Because we will bring it to its natural conclusion.
Well, their projected profits, I can't remember off the top of my head, but it was something about, was it 2 or 3 million they were going to make from this, from the car parking? So they're not just covering the costs, which they say are £427,000 for these car parks every year. They are planning to profit from it to make up their shortfalls.
They're planning to put it not into the specific parking service amenities. They're looking to put it into the general fund, Rachel, which again is inherently wrong. That's almost an abusive process. It's malpractice. So I've got no issues with this because I've dealt with so many councils, and we always bring it to its natural conclusion. At the end of the day, when they actually understand that they're dealing with people that aren't going away, that know the law, that know legislation and know the legal processes. And you've got somebody like me that's giving my time for free. I'm happy to do so. I will always do so. I'm not going anywhere. You know,
and you've got a team of experts behind you as well, which is, you know, I was very reassured when you said, right, I'm going to send this to people just to double check what I've done before you sent it to us. So that was, you know, really appreciated.
I've got unlimited resources in legal expertise and knowledge. Anything I don't know, I've only got to fire across an email or a message, and I'll get that answered from 15,000 other individuals who are either experts in that field. Because there's, you know, it's important that the councils know that, you know, you're not having to fund me. You're not having to find £200 an hour to hire a solicitor, a lawyer, to, you know, because that's how lawfare works. You know, they'll drive you into bankruptcy if they can. You know, individual bankruptcy, or just stall you until your money runs out. Well, I'm not going anywhere. I do this for free, and I do this out of service to others. You know, it's about time these people learn that mantra. It's service to others. They are serving their communities. And at the moment, they're doing a piss poor job. So me and 15,000 others have taken up the mantle. We are paralegals. We are expert litigators. We are solicitors, lawyers, attorneys, and we do this for free. And we're not going anywhere. Thy will be done. And we're doing this for the right reasons.
Yes, and it has to be done. If we don't start taking back control and power, and that has to come from local level and then work our way up. And we can do it. That's the thing. And that's what they don't seem to realise yet. But they will do with that number of you helping people. And also, as I said, in future series, what I would love to do is we all start learning how to do this, because it's one thing to walk into a council and serve them a verbal notice. But if you really understand the law, maybe not to the level that you do, but if we can get us to a level where we can be effective regardless, it's like having a lightsaber in your hand when you walk into the council. It's a whole different ball game. And that's where I think the more of us that do it, one, you become more empowered yourself. It's phase one is just plucking up the courage to go to the council in the first place and challenge them on anything. But we're all feeling it, certainly in our group in Colchester, that, yeah, we're on the hot air zone now. We actually need to do something more substantial. And with your help, certainly we can start to educate ourselves. I've bought the books that you recommended. Admittedly, I'm only on chapter 3 in tort law, as I've had rather a lot on my plate at the moment, but it is high on my reading list. So perhaps in a future interview, we can go through where everyone can start, and the realistic, how realistic is it for the average person? If they are willing to put some time in, can they get to a reasonable level? So I'll ask you that in a follow-up interview, if I may.
Most definitely. I think it's very important that we actually go over our rights. What rights we have, what our rights are, and how to enforce them, because we'll encounter civil rights violations, and civil rights are private rights. Okay, and your ability to redress that, if you've had a civil rights violation, the legal processes, the avenues, understanding the rules of civil procedure and criminal procedure. These rules, these courts have been put in place to protect us. So I think it's very important, first of all, that you and I sit down and we speak to your viewers about rights, what rights you have that are recognised in law. And you have so many rights, and you have so much power to enforce those rights, and I live this is due process. We have due process in law. It's a common law statute, observance of due process, that's been there since 1368. Okay.
Mm-hmm.
Now, modern day administrative law seeks to circumnavigate that. And unless you know your rights, unless you know how to enforce your rights, they can't take your rights, by the way.
No.
They can only violate. And when they do, they say, what are you going to do about it? Now, I enforce my rights because I know my rights and I know how to. That's the point. We can all do this. I promise you. It doesn't take a huge IQ. You haven't got to be Mensa. It's just, I will start you off on the right footing. If you and I want to sit down in the next one and we discuss rights, what rights you have, how to enforce them, where they're codified in superior constitutional statutes, common law statutes. And when you have that understanding, I'll give you the information to then read through. You'll process it and keep reading through it. And it will click. And I'll give you the books that you can buy for £2 or £3 off eBay. I'll give you the information. So I'll cut out all the nonsense and give you the direct route. So it requires a little bit of reading, buying some second-hand books. You'll know what the lawyers know, and then some. Because when you're unregistered, you can do what they can't, and you can hold judges to account. You can hold their feet to the fire. You can hold everybody to account. Because your knowledge, your understanding of legal process and the law, they can't get past that. There is due process of law. There are rules, and you hold them to the rules. And when you know the rules, it's no different to playing chess. Chess seems very difficult And most people go to a courtroom and they take their checkers pieces. They don't even know the rules of the game. I don't go to court because I know the rules. And I've hammered them into submission. I like to get their acts and statutes and beat them over the head with them till they submit. And they always submit. But I always give them a way out. And then I'll hammer them for damages and they'll settle out of court every time.
Brilliant. Well, I look forward to learning it, and I'm sure our audience will as well.
That's enforcing your civil rights, you see.
Yeah.
You've got all the power. We just never knew how.
Yeah, and we need to. The longer this goes on, or the worse it's getting, we need to. Absolutely. Well, thank you so much for everything that you've done. Certainly, I know the people in Sudbury are just beside themselves with, gratitude for what you've done so far. And, they're very grateful for the time and energy and effort you've put into this. And, they know how necessary it is. So they will do whatever you need them to do. And thank you so much for your time today and going through that letter, explaining it. And I would love to do a series with you. The power is within the people, but we've got to learn this stuff. There's no sort of getting away from it. We've got to know it. So thank you so much, Damian. Your time has been very much appreciated on all levels.
It's been an absolute pleasure, and God bless you all. It's a pleasure to serve others.
Now, a response to this letter before action has been received from Baber District Council, basically saying they haven't done anything wrong. So I will upload that to the Dropbox folder so that you can read it for yourself. It will be in the LAWMAN series, as well as Damian's letter before action. But once again, I reiterate, do not copy his work. You have to understand it. It is very case specific. So learn from his example, not copying his example.
So yes, tell me about your interesting conversation with the LGA.
With the pre-action protocol, obviously they followed that to a T with replying to our letter before action, or known as a letter before claim. So there is a certain pre-action protocol that has to be adhered to before we can actually, our pleadings before a judge, to overturn what we consider to be a poor or ultra-virus decision, an illegal and unlawful decision promulgated by this particular county council. The issue is this: you can go through the council complaints procedure, then escalate to the LGA, which is the Local Government Association, Ombudsman. And the LGA play a very important part in this because they've set out a councillor code of conduct that I can prove has been breached. The biggest issue we have is a time limit. Now, having a good chat this morning with this particular individual who was incredibly helpful. These people are very knowledgeable and really want to help. And he was absolutely stunned at the amount of signatories to the petition put forward from 3 small market towns to this particular district and county council. He was stunned.
Really?
Said,
that's interesting. Because you assume
Yeah.
they're going to take the side of the council the whole time.
No, they are an entirely independent body, and they put out the codes and protocols. And you're dealing with individuals, so you get these people on side. We had a very, very long chat. He's explained that obviously there's certain parts of what we're putting forward that their organisation can't take jurisdiction over. And that can only be attained through the judicial review. And I said, well, that's exactly as I thought. But obviously we have to follow a certain protocol. Now, I said, I don't want to go down the avenue of wasting more time and giving the council our complaint and having the council then monitor the council. I said, that is absolutely absurd. And he said, no, you're absolutely right. He said, so, no, you can escalate the complaint to us and we'll task you with an independent investigator.
Brilliant.
So what we will do is we will see, have they followed their protocols to a T? So we can't do anything about their decision. We can't overturn that. That's down to the judge. He said, but at the end of the day, you're following the correct protocol. And having submitted this to us, we can look at, have they contravened the procedures that they should be following under their code of conduct and their constitution? And I said, bang on, that's exactly right. And I said, I think I could prove perhaps they haven't. that gives us more weighted evidence to put in front of the adult in the room, the judge. All a matter of following procedure, because their legal brief will shut this down very quickly if, just on a procedural deficiency. So we do everything by the book. And by doing so, it's called an alternative dispute resolution. We're giving them the opportunity. With this kind of thing, it comes down to persistence. They're testing our mettle. How far are they prepared to take this? And it's a similar thing that you and I will discuss, because obviously we're going to be doing a piece on rights and the fact that people don't realize they have rights. And you have rights and you can enforce them. And you're going to wonder why you were never taught this in the education system. Why were we not taught your rights? And you'll all come to the same conclusion, which is perhaps they don't want you to know you have rights and how to enforce them.
Definitely. But with the LGA, if they do find in our favour and the council haven't followed the right procedure, then what happens? Do the council have to then say, OK, we'll scrap the car parking charges? Does that then give them another opportunity to go push it through again, but following all the procedures? How does it work? Right.
Well, they would risk a fine. We would continue down the alternative dispute resolution. They would have to, I would think, then rescind their action if they haven't followed the correct protocol. And they continue, then it's a shut case, isn't it? We've proved a breach of trust, right? A breach of protocol. The weighted evidence, the fact that they've ignored a huge petition, and the fact that they've contravened legislation. They haven't balanced their books. It's not for them to then further impoverish their local community who have already put in a petition and said no. So you have the business, the corporate side, which can quite easily put in for a grant at central government to cover their losses, right? There is a mechanism with which they can get extra funding if there's a shortfall in their finances. It's not about then putting another tax on the local community in the form of parking charges.
Well, their argument will be that there's no guarantee they get that funding. But so do we? They might have already tried, for all we know.
Hey, Rachel, that's not our problem. Their protocol was to put out there, what do the public want? What are the public wishes? Well, it's a resounding no to your parking charges. And here's a petition. That being the case, they're not following their protocols, and they are designated in the Local Government Act 1999 to be a best value council, that they have to have regard to the economy. Everything they're doing is to the detriment of the economy. Yeah, and it is my belief that they believe that statute applies to their own economy. I think they've misinterpreted the statute. That's why they would. Yes.
Yes. Gotcha.
Do you see?
Yep.
Because they were very resolute. We will defend this in their reply. I believe that they have misinterpreted the statute. How have you come to this conclusion over here? This is La La Land, an opinion. I'll just deal with the facts, yeah? And I'll put that in front of the adult, which is the judge, who can also interpret the statute. It's not rocket science. Jurisprudence is the science of law, and it's the application of, and that's also to do with the interpretation. So with regards to the LGA, they're on side. I'm dealing now with a specific guy there internally and directly. And that's the power of courtesy. Yes. So they've rightly said, they cannot overturn the decision, but they can point out and fine them and hammer them really on any procedural deficiencies, which I can prove. So the next stage is going to be writing a letter for the independent investigator with regards to what I believe are their deficiencies to add weight to our argument. Now, I think they'll just keep going to the last. I think, and it could go right to the very day where they've got to step into court.
Yeah, I think so.
They fold. Then they fold.
Yeah.
They take it right to the wire. We've formed a partnership here because of our persistence and our moral code.
And also they think if it's going to cost them a fortune in legal fees, if we just keep going and going, that will crush them, not realizing that so many of us are doing this, you know, free of charge because it's what we believe in.
It's costing you nothing. Just my persistence, and me enjoying being part of the bigger picture and serving others, having service to others, you know, which is probably a unique concept to these people with these huge pensions, especially the statutory officers. In these corporate setups, you know, the servants believe they're the masters, and that's not the case. And if they could interpret their own statutes correctly, they'd realise that's not the case.
Well done on reaching the end of this video. If you'd like to leave me a comment saying you made it to the end of the video, please do so below. In the next episode, that's probably going to be one of the most important videos that Damian and I do together. And that is going to be on your rights and knowing what they are. Because if we don't know what our rights are, we're going to be trampled over by authorities and companies left, right and centre and paying bills and fines unnecessarily. So we'll look at that in the next episode. And that episode will be out in the next week or two. So if you like more of Damian's work, which I highly recommend, then go over to Gavin's YouTube site called Sovereign Empowerment and you will see his LAWMAN series. And that is really worth your time watching. So until next time, take care. Bye-bye.